Today I am here to represent schools with regards to negligent liability for bullying within schools. Schoolyard bullying is not a new phenomenon. However, as community standards change and the acceptance levels regarding such behaviour are lowering, there is an ever-increasing rate of parents or past students suing schools for failing to prevent children from being allowed to commit such intolerable behaviour. Such plaintiffs argue that schools breach this duty of care by failing to uphold any anti-bullying policies within the school and by taking reasonable steps in preventing the bullying, and as soon will be discussed, precedent has shown there's a very strict adherence and high level expected from schools with regards to this duty of care. However, I believe bullying is a much more complex issue than simply forcing a school to strictly implement an anti-bullying policy. A recent report by the Organisation for Economic Cooperation and Development has shown that Australia has the third largest amount of school bullies, with 30% of school children reporting to have been bullied, which is 7% higher than the world average of 23%. A clear indication that the current deterrent system is failing. As will be discussed later, I believe that simply suing schools does little in tackling the larger issue of bullying within schools. While suing the school does provide a form of justice to the victim, it does not, however, put in a system to deter the behaviour as a whole within the schooling system. Just merely stops it from repeating within the select school being sued. If such legal claims are to be continually provided by the courts, this will eventually open a legal floodgate of plaintiffs suing their past schools as the current standard to which schools must uphold the current duty of care to prevent bullying behaviour is far too high and thus can be easily defeated in the court. There is no denying that a school authority clearly owes a non-delegable duty of care to take reasonable steps to protect all those enrolled in their school. The scope of this duty has not been judicially set in stone. However, the 1977 High Court decision of Gare and Downs has given some guidance in the matter, with Stephen Justice stating, "The duty of which a school owes to its pupils arises from the relationship between them, and its temporal ambit will be determined by the circumstances of the relationship on the particular occasion in question," effectively establishing that a school's duty of care is much wider than simply within the school grounds during school hours. However, how far does this scope of non-delegable duty of care extend in instances in which the school does have anti-bullying policies in place and took reasonable steps in preventing the behaviour? This was importantly observed in Oyston and St. Patrick's College by Smith Justice, stating that despite the school having anti-bullying policies in place and keeping records of the behaviour, this was held to not be sufficient enough. Smith Justice's reasonings was the school did not adequately classify inappropriate behaviour as a form of bullying, and failed to properly record every bullying instance to the students' files, therefore breaching the non-delegable duty of care as a school by not taking enough reasonable steps in preventing the behaviour, and therefore should be held liable for the suffering brought upon the plaintiff. However, why should the school be held liable and not the bully? Furthermore, what is defined as reasonable steps for a school in terms of preventing the bullying behaviour of the students, and how far are educational institutions expected to go? The New South Wales Supreme Court case Cox in New South Wales is an example of such steps required by the schools. Over a number of months, the plaintiff, Cox, was subject to repeated cases of bullying by an older schoolboy at Woodbury State School, which later resulted in Cox's mother moving him to another school due to the school not sufficiently enough preventing the bullying. It had been established that the bully had suffered from attention deficit disorder, or ADD, which explained his antisocial behaviour. On numerous occasions, the school punished the bully, kept the pair separated as best they could, was in contact with his parents, and even to the point where the police were involved to talk to the bully's parents. Despite all this, the Supreme Court still held that due to the repeated bullying being foreseeable, the school was therefore required to take greater than normal steps to prevent such behaviour from occurring again, thus breaching the non-delegable duty of care. This is essentially the law requiring an educational institute to overstep what is required of the non-delegable duty of care to protect students from physical and psychiatric harm. In the case of Cox in New South Wales, it is hard to ascertain any other way the school could have possibly prevented the bullying, importantly considering the school is a state school and most definitely has less financial funding than a private school. It is therefore onerous to expect state school staff, who most likely only have a degree in primary teaching, to adequately deal with a bully suffering from ADD. By the facts given, sounds like most likely requires special needs staff. Another big issue to school bullying negligence is establishing a solid causal link between the breach of duty and the damage suffered. The English case Bradford Smart and West Sussex County Council importantly summarised the difficulties surrounding causation, stating, "It is not enough to find that there has been bullying, to find some breach of duty, and then to find that the bullying caused the injury. There must be a causal connection between the breach of duty and the injury. That will be often difficult to prove." Furthermore, the same goes for Australia and Queensland, with applying the but-for test under Section 11(1)(a) of the Civil Liability Act. A plaintiff must prove that but for the school's breach in upholding anti-bullying policies, he or she would not have been bullied. However, despite what precedent has shown, from a realistic point of view, it is hard to ascertain whether simply enforcing anti-bullying policies on an antisocial child, such as contacting the parents, or detention, would in fact stop the child from bullying again. A dissenting judgment by Samuels Justice and Ryan and Haynes reinforces this notion, as he argued the possibility that disciplining a bully and upholding anti-bullying policies could deter such behaviour from repeating as entirely speculative. Furthermore, he also argued that supervision on its own is not enough to prevent bullying, given the fast nature that bullying acts occur, especially physical ones. Therefore, erroneous to state that a school has breached its duty by not providing enough supervision or enforcing anti-bullying policies enough. Furthermore, common psychosomatic symptoms that could arise from bullying include low self-esteem, low self-worth, headaches, irritable or bad temper, difficulties sleeping, depression, and anxiety, just to list a few. However, importantly, these symptoms can also be linked or associated with the common hardships faced with growing up and continuing through puberty. Furthermore, every person, including children, have different thresholds to physical and emotional aggression or low-severity bullying, and has been considered an important factor in a child's development to cope with the natural stresses and demands of modern society. Consequently, this creates the difficult situation of assessing on the balance of probabilities what is a normal person's threshold and if the bullying was enough severity to cause such harm. For instance, in the Oyston and St. Patrick's College case, the 21-year-old plaintiff, whom experts believed was sensitive to psychological injury due to her home situation, was subject to mainly verbal name-calling bullying by the popular group, and the occasional jostle walking between classes during grades 7 and 9. The school did take steps to prevent it, such as through detention, providing counselling to the plaintiff, and even providing professional training to all staff to recognise bullying. However, despite attending another school for her remaining years, her poor home environment and sensitivity, and waiting until 4 years after leaving school to bring the action, a total of 7 years away from the bullying, this 2-year period of name-calling was held to be enough to have caused her crippling psychiatric illness. To conclude that this is enough to satisfy as a causal link, which is suggested to be difficult to prove in such cases, is an example of the courts favouring the plaintiff, the bullied victim, in the school bullying negligent cases. The cases Cox and Oyston are clear examples of the courts favouring the plaintiff, making a harder argument for the schools to defend themselves. While this soft approach from the courts does benefit the plaintiff by providing a form of justice, it does not, however, tackle the greater issue of bullying within the school system. For instance, in both cases of Cox and Oyston, both had to wait until after graduating school to bring a claim. During this time of waiting, of leaving school, the perpetrator, the bully, has since graduated school and left. Therefore, when it comes time to bring an action against the school is the only party being punished for its actions, not the bully or the bully's parents, thus allowing the bully to develop their antisocial behaviour into adulthood and not be punished for the arguably serious antisocial behaviour during school that was enough to potentially ruin a plaintiff's life after school. As statistics have shown, Australia has the third highest bullying rates in the world, suggesting that the current anti-bullying system is not working in preventing such behaviour among children. Therefore, I am suggesting in cases such as in Cox, in which the school did all they possibly could to the point of involving the police, therefore arguably taking all reasonable steps possible, that perhaps juvenile punishment should be involved. Creating the potential of juvenile punishment could serve two purposes. First, the fear alone of having to face real consequences beyond school detention for repeat bullying could make the bully more seriously consider their actions, similar to how a child considers their actions before committing other common juvenile crimes, such as stealing or break and enter. Second, this will provide a form of justice on the bully as an individual, thus making them responsible for their own actions rather than reflect on the school as a whole. As already been explained, simply having anti-bullying policies is not enough in preventing the complex issue of bullying. Therefore, having the system in place, once the school has already taken all the reasonable steps they can, could potentially deter bullying within the school system and not expect schools to overstep their place as an educational institute to uphold the kind, strict and unreasonable duty of care expected. Furthermore, an additional recommendation that could possibly aid school bullying negligence is making use of Section 22 of the Civil Liability Act. Section 22 allows the court to refer to a responsible body of expert opinion unless no reasonable court would do so. However, currently there is no accepted teaching profession standard for bullying cases. Potentially having an accepted teaching practice with regards to handling pupils who bully and what steps could be taken could help courts answer difficult questions such as what is considered reasonable steps by a school and the scope of their duty of care. An example of this recommendation can be seen in the English case of S and London Borough of Redbridge, in which the courts compared the school's authorities' response to bullying to accepted teaching practices. As clearly shown, it seems the courts are forgetting that schools are a place of learning and that there are limits as to how far they can possibly go to prevent a complex issue of bullying, and it is not the only contributing factor that can cause damage to a plaintiff. That is why I believe at the present time schools are being unfairly treated with regards to school bullying negligence claims.